Namaste everyone. Today we will be discussing about the law that you've learned, that is the law of contracts in practice, as to how you're going to implement that law into drafting of a contract. Now, while keeping drafting of contracts in mind, there are a few general principles that you need to bear before going ahead. What are they? Firstly, let us understand what drafting is. And generally, what do you mean that when a lawyer says that I engage into drafting of contracts? What does he mean when he says so? Drafting in legal sense means the act of preparing certain documents such as agreements, contracts, deeds, etc. What are the differences amongst the three? Please note they are just a common phraseology which is used and it bears the same meaning. So the division of what an agreement or a contract or a deed that has become more obscure in today's era. But in the earlier times, generally documents where title has been transferred was generally referred to as a deed, and certain aspects where services or some other aspect has been engaged was called an agreement or a contract. Now you must certainly know what the difference between agreements and contracts are. Now there is a particular premise which says, a contract is an agreement which is enforceable by law. But there are certain agreements which cannot be enforced. For example, a memorandum of understanding. An MOU is also something that can be drafted, and you can have a particular premise that a memorandum of understanding is not enforceable, and as such, even those aspects which are not contracts can be drafted. That is the first premise that you need to keep in mind. Further, drafting is generally a synthesis of law and fact in a language form. What do I mean by that? Now, for example, if you're going to sell a property, let us say a land which has a building affixed to it. Now, what is the fact? The fact is that there is a building attached to land. What is the law? The law is that the title of the land and the building belongs to person X. Now, when you're drafting a contract whereby X is going to transfer the property to Mr. Y, that is where you're bringing a synthesis of both law and fact into a particular documentation form. That is what drafting leads you to. Certain aspects or ingredients are essential when you're looking to understand what is a good draft of a contract. First thing is, and most paramount of everything, is the understanding of the law. Because anything that you draft contrary to the legal position or to the legal scenario is going to be held to be void. So I'm sure you must have learnt about void agreements. Anything that you do against the law is void ab initio. So they cannot be enforced at all in the first premise. So as such, understanding of the law is very important. By understanding the law, what do I mean? There are certain essential features, like say for example, just to make you understand, I use the concept of bailment, pledge, lease and surety. You need to understand what is the concept of bailment. You need to know what is the concept of pledge. For instance, pledge is a form of bailment. But the only difference is that in case of a pledge, there is some property that is used as security for a loan or a credit that is availed. That is the particular premise as to the distinction. So you must clearly be aware as to what is the particular law when you are drafting an agreement relating to such law. Next, understanding the factual scenario is extremely crucial, because a draft is nothing but a synthesis of both law and fact put together. Like for instance, if you are going to say Mr. X, son of Mr. Y, you need to know the entire history while you're putting it into a particular draft. If you mention Mr. X, son of Mr. Z, it becomes completely contrary to the fact. And as such, the contract becomes unenforceable because of an ambiguity of both factual scenario and the legal scenario that you've created. So please bear in mind, friends. So understanding the factual scenario is extremely crucial while going about it. Next, it is also essential to use coherent choice of words or appropriate language and punctuations. Now you may say, sir, what is this? Is this an English grammatical class that you're trying to tell us? But I'll give you a scenario as to why it is very important to use coherent choice of words, appropriate language, and punctuation marks. What do you see on the screen? You see that a particular man is holding a noose. What is he going to do with this? It depends on how you're going to draft the particular sentence. Hang him, comma, not let him free. What do you understand by this? It means that let him put the noose around his neck and get hanged. Right? Now please note, I am just making a point over here with regard to the punctuation mark, which is a comma that is used in this slide. Just by shifting the comma to next to not, what have I done? Hang him not, let him free. Did you notice? In one of the sentences, his life is taken away. In the other, his life is given to him. So that is the importance of a punctuation mark while going about drafting. Is conveyancing different from drafting? Now you might have heard that few of the practitioners say that I am into conveyancing only. I am not into any other particular areas of practice. So what does this conveyancing mean? Like I brought out the discussion between the difference between a deed and a contract and an agreement initially, conveyancing differs from drafting in the traditional sense alone. In the sense that conveyancing is referred to that form of drafting where you are into drafting of contracts which relate to sale or transactions related to immovable properties and not otherwise. But nonetheless, it has become more obscure today, and conveyancing and drafting, the shade between them is just a small thin line, and you can say that on common parlance they mean the same thing. With this, we move on to something called what is the importance of drafting. I have already given you one particular instance as to the person being hanged, and I also told that we will introduce you to a particular case where the use of a punctuation mark created a huge difference. Now this is a particular clause that was there and in a contract. So it said that there shall be no overtime wages for workers in the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of perishable goods. Now please note that in the first phrase I have just highlighted the aspect of shipping or distribution of perishable goods. In the second aspect, the same clause is there with a punctuation mark, which is a comma. Now, what is the difference between clause number 1 and clause number 2? You may ask me. So, it is the same thing. There is just one comma that is added. But please look at it, my friends. This is a particular provision that I have taken from a legislation. From the two clauses that we have on the screen, there is a question that needs to be answered. The question is, are workers in the distribution of perishable goods entitled to overtime wages or not? Please read clause number 1 and clause number 2 separately before answering this question. I'll give you about 15 seconds. One of the reasons why I'm giving you this particular aspect is to understand how much of a difference a punctuation mark can do to you. When I use a punctuation mark next to the word shipment on the aspect that is highlighted, the difference is almost a sea change. If your answer to clause number 1 is yes, then you are absolutely correct. And if your answer is no to clause number 2, then you are also correct again. Please note the aspect of those involved in distribution of perishable foods are entitled to overtime wages in the first clause because it is to be read as packing for shipment or distribution. So packing for becomes an additional word that has to be read as a prefix to distribution. So as such, those in the distribution industry are entitled to wages overtime, but because the word distribution of perishable foods is not excluded from the clause. But if you look at the second aspect, those involved in the distribution of perishable foods, they are excluded from being entitled to overtime wages merely because of the use of the punctuation mark, packing for does not become a prefix to the word distribution. That is the essence of drafting. With this, we move on to another essential ingredient, which is called the $1,000,000 comma keys. Now, why do you call it a $1,000,000 comma keys? Is because the use of one comma cost the companies millions of dollars. How, you may ask? This was the particular clause. Now, there was a telecom company and another entity which required to exercise the cable lines of the telecom operator. Now, it so happened that the clause had a particular provision that says that this agreement shall be effective from the date it is made and shall continue in force for a period of 5 years from the date it is made, comma, and thereafter for successive 5-year terms unless and until terminated by 1 year prior notice in writing by either party. This is the particular clause that is there in action. Now, I'll tell you which is the particular comma that cost them $1,000,000. Now, there are two commas that are used here. Now, if you look at it, what is the premise of understanding? Can the contract run initially for an entire duration of 5 years, or should it run for a successive period of 10 years, or can it be terminated at any point in time? Now, please note, there are two commas that is used. One of the comma is the only thing that cost them $1,000,000 because the agreement was terminated before the completion of 5-year duration. What was that comma? It is the one that is being circled on the screen. If you notice it, I am recircling it again. Please note, the use of this particular comma required that the entire requirement that the contract should be valid for a period of 5 years could be terminated by 1 year prior notice, which means that if a contract comes into operation today and is to be running for a period of 5 years, at any point in time I can give a 1 year notice to the particular opposite party and I can terminate the contract. Now, this is the reason as to why punctuation marks should not be unnecessarily included within the clauses. One of the fundamental rules of understanding what a particular clause means is any line, and this is just a general rule, any line that comes between two commas can be read excluded from your interpretation. So, which means that this agreement shall be effective from the date of execution for a period of 5 years unless and until terminated by 1 year prior notice in writing. So that is the premise of understanding which generally courts will take into consideration while interpreting a contract. So please be very careful that a punctuation mark can kill a business. Next, we move on to the premise of what is drafting and what can be drafted. We have already understood that drafting is generally a synthesis of law and fact being recorded. So in common parlance, it is called getting the documentation ready. Now, what do you mean by getting documentation ready? So for that, you need to understand what documents are. Documents have been defined under the General Clauses Act to mean any matter written, expressed or described upon any substance by means of letters, figures or marks, which is intended to be used for the purpose of recording that matter. Please note, now the aspect that is recorded here is written, expressed or described by letters, figures or marks. Now this is something that you need to keep in mind, that documents does not necessarily mean something that is in writing in terms of words or letters. It can also have certain marks, it can also have certain symbols that is used across and other aspects also. Like say for example, if you're going to take a sale deed in one of its scheduled properties is also going to have a sketch of the property itself. So as such, documents can also include sketches wherein marks or figures can be used to make you or understand the reader what the transaction is. Documents also includes the following aspects: contracts, agreements, deeds, MOUs, appointment letters, etc. Now these are the basic premises which probably you will get to know based on common usage. Now, contracts, you quite clearly know, any agreement that is enforceable by law is a contract. Agreements, yes, there can be agreements that are not enforceable also, right? And as such, one such form of an agreement which cannot be enforced is a memorandum of understanding that clearly tells that it is not binding on the parties. Deeds, I think I've already suggested to you that they are something that relate to a particular transfer of immovable properties. Memorandum of understandings, yes, we just had a discussion about it. Appointment letters, employment bonds are also certain other examples. Drafting can also include the terms and conditions or privacy policy of the website that you are using. You can check out the terms of use and privacy policy of the NPTEL website also. You can check out the terms of use and privacy policy of Amazon, for instance. All of these terms of use and privacy policy and your appointment letters, the MOUs and other aspects have certain purpose that they are in existence for. What is it, you may ask? They tell you what are the particular terms and conditions that apply to a given transaction. Like say for instance, in a sale deed, the terms and condition are the buyer is going to purchase the property for a consideration of X rupees. And the seller is required to transfer the title of those property into Mr. X. So that is a particular aspect that you need to keep in mind, that these are the facts that are recorded. Now, in terms of marks and others, the sketch of the property is included in the sale deed. In terms of words, it is said that the buyer shall purchase for consideration. And in terms of figures, you have the amount of consideration that is given. Let us say, for example, 1 crore. 1 crore will be written in both numerical font as well as in word form. So these are aspects that you need to keep in mind as to what documents are. Going further, there are few essential rules of drafting that you need to follow. What are those? Now, there was a particular researcher who gave 5 essential rules of drafting. Now, what are those 5 rules? He says drafting should be direct, simple, brief, vigorous, and lucid. Now, these are just the 5 particular premises which he says when you are going to go about drafting a particular contract or a document. These are the 5 rules that you need to keep. Do not keep it very indirect. Do not keep it very ambiguous. Do not keep it very elongated. Do not keep it, in a manner which does not hit your comprehension. So these are aspects that you need to keep in mind. One of the particular aspects or essentials, if you are going to, subtract these 5 rules into multiple points, is that prefer a familiar word to a far-fetched word. Forbearance as against restraint. Now that is a particular point that you need to keep in mind when you are going about it. Then prefer a concrete word to the abstract word, in the sense that there are few words that have a better meaning to it. Do not use words which are very ambiguous. Like say for example, work hard to construct. Now this is a particular aspect that is not concrete enough as against effectively construct. Now when I say work hard, what do I mean by it? He might be doing the work continuously for about 9 hours of duration, but he might not end up getting the building constructed. The clarification is quite obscure here. Prefer a single word to a circumlocution. Now what is this? He has a large house. Now large house is a particular aspect, which is a single word. If you look at the circumlocution word, it is a descriptive aspect. He has a house that could fit 100 horses and a few elephants. Now, in case of drafting, you don't require to give such a big descriptive circumlocution, because it only makes the contract more ambiguous and susceptible to interpretation. The next particular point that you need to keep in mind is the need to prefer a short word to the long word. And also prefer the English Saxon word to the Roman word. Good faith. Now in common parlance, good faith is something that is used much wide as against bona fide. Although bona fide and good faith mean the same, it is preferably that you can use the aspect of good faith rather than bona fide. And the last rule that is to be kept in mind is always prefer active voices as against passive voices while drafting of documents, because it gives the reader a clearer picture of what the transaction for which you are drafting the contract to be. There are a few guiding factors that need to be kept in mind, and these are just general principles. Now, there may be more stricter and more specific rules based on the transaction that you are working on, or based on the particular nature of the law that you will be drafting the contract in relation to. The couple of these guiding factors are bare essentials that you need to keep in mind. First thing is numbering of clauses and pages. Now, sometimes you find agreements that run from line 1 to line 10 without a particular numbering of any sort. It starts with I so and so, son of so and so, and ends with hereby witnesseth that. Now, this is the particular aspect that needs to be avoided. So if you're going to look at this particular aspect, numbering of clauses gives in a particular sense of clarity in what the contract essentially means and what it tries to convey. Numbering of the pages gives that the document in hand has a certain fixed number of pages. Now, as an essential practice, I use the particular page numbering format 1 of dash total number of pages. So 1 of 10, 2 of 10, 3 of 10, these are the format of numbering which I prefer to use. And clauses, I would suggest that you use a systematic continuous numbering format wherein you start with 1 and end with X number, whichever it goes in a continuous flow. The next aspect that you need to keep in mind or bear in mind is use of annexures or schedules appropriately. Now, a couple of this is a particular principle that few advocates differ in. Few of them insist that let us not have annexures or schedules. Let us have the entire agreement drafted into the main text or main body of the contract itself. Now, there are certain aspects, probably when you must reconsider this particular point of view. Now, in case there are certain things which are non-essential factors, like say, for example, the description of the property and with regard to the sketch of the property, and it could be something in case if it is a contract relating to the service, the quantity of goods that is to be supplied, the price relating to each of these goods, it is preferred that you can remove it from the main body or text of the contract and include it suitably in an annexure or a schedule. This allows the contract to be interpreted without any interference as to the particular non-important or non-essential ingredients of the contract. Now, one may say that, if you're going to include it into the schedule can always be changed. That is where the numbering of the clauses and pages is very essential and crucial. Please note that when you have the total number of pages put or inserted at the end of every single page, you know that when a contract ends, there are certain schedules because the schedule is also included in the numbering. So as such, you can suitably include annexures and schedules also. And the last particular aspect I would suggest is try as and much to avoid using negative sentences in successive phrases. Now, the reason I say this is because when you use two negatives, like the math rule goes, two negatives make a positive, applies also to drafting. Like say, for example, if you don't want somebody to enter into a particular room, this is the particular clause wherein somebody decides to go ahead and drafting a contract. No person shall not enter the room. Now, if you look at it, this sentence is not direct. It is something indirectly being spoken about. So, one of the particular essential rules is have it simple and direct. Now, this is one of the two premises that is brought about completely against. And also, there are two negatives that is used. No person shall not. Now, if you're going to interpret this, it means that every person shall enter the room, because no person shall have the opportunity not to enter the room. That is what the particular clause means essentially. Now, on that note, I would suggest that in case you don't want something to happen, please use a particular different formatting method for defining the sentence. Do not use negative sentences in successive usage so that it avoids ambiguity and brings in certainty to your document.